Hello everyone, welcome to our Great British Entrepreneur Awards webinar with Anthony Collins. In this session, Chris Lloyd-Smith, along with guest speaker Aimee Fox, will cover why couples enter into prenups prior to marriage, their current legal status, and in what circumstances they are upheld. The session will also cover how courts approach businesses when looking at marital finance, and they'll also explain how things are different for unmarried couples who cohabit. There is an opportunity to ask questions during this session. If you have a question you'd like to ask, you can pop this in the Q&A function at the bottom of your screen, and we'll do our best to answer these later on in the session. And with that, I'll pass over to our speakers today, Chris and Aimee.
Well, hello everyone. I'd like to introduce you to today's webinar. The title is Life Stage Planning, Prenuptial Agreements, Relationships and How Courts Look at Business Assets on Divorce. How do you protect your assets? So my name's Chris Lloyd-Smith. I'm a family solicitor and partner at Anthony Collins Solicitors. We're a specialist law firm based in Birmingham and in Manchester. In my daily life as a solicitor, I often get instructed by clients who are either business owners or the spouses of business owners, so I'm well aware of the issues that surround businesses when relationships come to an end. Alongside my role as a solicitor, I'm also an accredited family mediator. As a mediator, I work with separated or separating couples in resolving issues either about children or financial matters on or following a separation. As part of that role, I can speak to children directly where appropriate so that they have a voice within the mediation process and parents can consider their views when making proposals to one another. Also with us today, I have Aimee Fox.
Morning, everyone. I'm Aimee Fox. I've been working with Chris for a number of years now on family breakdown, including matrimonial breakdown, in my role as a barrister. I've been practicing as a barrister for about 10 years now. Before that, I was in Brussels. I was an associate in the competition team of Clifford Chance and later went to the European Commission to work on merger control. So when I started my legal career, it was very much in the business domain and looking at how business operates and making sure they're not too dominant. I do similar work to Chris, but I would be in court probably a bit more because of the difference between barristers and solicitors. Chris has tasked me with explaining in a nutshell what the different parts of our legal profession are in this jurisdiction. I would say with some degree of confidence that Chris would be your first port of call and probably your first interaction with the legal profession if you are going through a separation or a divorce. Usually people will get on the phone to their solicitor, have a meeting and start the ball rolling with whatever they need to do. We come in usually later down the line if there's a application to the court and you need to be represented in the court proceedings. I say it's teamwork. Your solicitor will be guiding you, preparing applications, preparing witness statements, giving strategic advice. And alongside that, we'll be coming in with our opinion and getting your case ready to go to court, where we'll be there on the day as your voice and your advocate. And if all goes well, both your barrister and your solicitor will have had a role in making sure that you get the right outcome and the fair outcome in what can be really, really difficult circumstances. So that's the difference in this country, barristers and solicitors working together. In other countries, you'll see you just go to your lawyer, like in the States where you have an attorney. It's a bit different here. So over to you, Chris.
Yeah, I think we're on the next slide now, aren't we?
Thanks for the reminder. And before, oh, I've missed my second slide. Before we do that, what I should say is you always know there's lawyers in the room when you get a disclaimer. So without further ado, our disclaimer is that nothing that we say during this seminar constitutes actual legal advice. If you were in a situation where you were divorcing or separating, then it is worth going and getting some legal advice. And we cannot be liable for what you might rely on based on what we say in this presentation. So that's the legal bit over.
It's quite often why solicitors instruct barristers for that sort of level of cleverness. So thank you for that, Amy. Right, so back to me, I think. So the title of today's webinar is Life Stage Planning, Prenuptial Agreements, Relationships, and How Courts Look at Business Assets on Divorce and How You Protect Your Assets. So where to start? Well, where to start is prenuptial agreements. Prenuptial agreements, what are they? Why are they entered into? How are they entered into? And what are their legal basis? So first of all, can I just clarify that there are actually two types of agreement? There are prenuptial agreements, which are entered into before a marriage takes place, and postnuptial agreements, which are entered into during the marriage. The term nuptial just simply means marriage, so the pre or postnuptial means an agreement made before or during that marriage. The purpose of the nuptial agreement is to enable parties to set out their financial intentions in advance of or during their marriage in order to define what should happen to their joint and separate assets in the event that they subsequently separate permanently. Whilst they are in some other countries, nuptial agreements are not currently contractually binding or automatically upheld by the courts in England and Wales. And if they're not, then why would people want to enter into them? Well, the answer to that is this. If they are entered into correctly and are fair, the court will uphold them. This was confirmed in the family law case of Radmacher and Granatino, which is from as way back as 2010, but is still the current law. So how are they correctly entered into and what constitutes fair? In terms of being entered into correctly, that means the court would expect both parties to have taken independent legal advice at the outset, and where there are one and be aware of one another's financial position, and being by implication the effect of the agreement that they were entering into before signing the agreement. This is ensured by both parties instructing lawyers and undertaking an exchange of financial disclosure before the agreement is negotiated, and the disclosure itself is recorded in a schedule to the agreement. This allows a judge, if the agreement is ever tested, to look at the agreement and the assets that were disclosed at the time, all in the same document, to decide whether its terms should simply be followed. There also needs to be no indication of undue influence or pressure being applied to one or both parties. The court would expect the agreement to be freely entered into by both parties, with the prenuptial agreement also having the need that it should be entered into at least a month before the marriage takes place. And for the avoidance of doubt, that means that the document should be finalised and signed at least a month before the marriage takes place, not that negotiations commence a month before. In that circumstance, it would be far too late and would almost certainly lead to the assumption of pressure if ever tested by the court. In terms of fair, that's much harder to accurately quantify, as fairness changes in every single case. In essence, though, a court would be unlikely to uphold a nuptial agreement or find it fair if it did not meet the parties' needs, and particularly housing needs. This is all the more important. Phone's going off. That in there. This is all the more important where if there are children of the relationship. So that really should be the start point for the negotiations. What are the needs and how can they be met by the available separate and joint property that the parties have? Whilst everyone's view is slightly different, my approach to the terms of a nuptial agreement is generally this: that there's little point in entering into one if it's similar in its terms to what a court might order, as you're not really protecting anything. If you do that, you are, however, I suppose, adding a degree of certainty. Similarly, there's no point in entering into an agreement that's so unfair and doesn't meet needs, as a court simply won't order it, irrespective of how it was entered into, whether it was properly entered into or not. The goal of a properly constructed prenuptial agreement is to protect one party, usually the party with more wealth, departing from settlement terms that the court might order, still meeting needs, but importantly, departing from what the court might order, for a particular and stated reason, which is set out in the nuptial agreement. If that's the goal, what are those reasons? What are the circumstances where you might consider entering into a nuptial agreement? Well, firstly, it's important to consider a nuptial agreement if there are children from a previous relationship or marriage, as you may wish to make specific provision for those children, or otherwise ring-fence certain, particularly pre-acquired family assets for them. A second reason is whether you have business assets. You may wish to protect the business that you've developed or the intellectual property you've come up with, possibly many years before the relationship began, in the event that the marriage ends. You may consider entering into a nuptial agreement where there are future or actual inheritance prospects. And another circumstance is where one party has substantially higher assets or a larger asset base than the other. Finally, you may wish to enter into a nuptial agreement, or it may be desirable to do so, where one or both of you have been married before and want to avoid the repetition of arguments, costs, upset and delay that was involved in that first divorce process. And so where one or more of those exists, we would advise clients to consider a nuptial agreement, and indeed see nuptial agreements as no different to, say, something like a will. Good financial hygiene. Indeed, I recently read that 1 in every 5 marriages now is entered into with a prenuptial agreement accompanying it. So it is more common than it was some years ago. So if that's why you might want to enter into a nuptial agreement, what are the pros and cons of doing so? So firstly, the advantages. So the first advantage is clarity and certainty, as I think I said. You make clear what each of you have, what's yours, what's theirs, and what's joint when entering into the marriage, and by implication, married life. Furthermore, you make clear how those assets are going to be divided if the relationship comes to an end. This has the added benefit of saving money, time, and upset down the line, as negotiating and litigating financial matters can be incredibly expensive and time-consuming. By implication, a nuptial agreement protects assets, so property, businesses, savings, but also heirlooms, inheritances, gifts, can all be ring-fenced within the agreement. Debt protection. If one party falls into debt during the marriage, a nuptial agreement can protect the spouse's assets from those liabilities. It can compensate for a loss of career. You can agree that if one party were to give up work, say to look after children or an elderly relative, that person can be compensated for doing so as to reflect the loss of earnings or earning potential going forwards. And this is something that's very hard to convince a judge of in financial remedy cases. You can protect business and business partners. If you're a business owner, the nuptial agreement can protect the asset and disruption to the business in the event the relationship ends. It can prevent the other party seeking a share of the business. It can also regulate what happens to a spouse who is an employee of the business, which is a common thing that we see. Provision on death. A nuptial agreement can set out what happens if one of you were to die. This can support the provisions of a will, but in any event can protect assets, relatives, children, indeed grandchildren. And not to be sentimental, love. Whilst a nuptial agreement can be seen as unromantic, entering into one is really good evidence that you're doing it for the right reasons, for love rather than money. And finally, it's your decision. A nuptial agreement is your agreement. You can be far more creative than a court can be, and you can make the agreement do what you want it to do. It's not what a judge thinks is right, it's what you think is right. It's not all good news though, and there are some disadvantages as well, as I say. These include, as I said earlier, that they're not legally binding. It's not 100% watertight. And of course, the law could change. It could become binding in the future. It could become less persuasive in the future. You don't know. Which leads me to crystal ball gazing. When a court looks at an agreement, the first thing it will look at is, does it meet the needs of the parties? And as I say, any children of the marriage. How do you make provision for any children when you don't know if you're going to have children, how many you may have, and when you may have them? Even if you do make provision for children, you cannot in any event oust the jurisdiction of the Child Maintenance Service. Either parent can apply for the Child Maintenance Service, irrespective of what the terms of a nuptial agreement might be. And there's even more crystal ball gazing. An agreement can't predict everything that will happen and any all significant changes during the course of a marriage. Should circumstances change, and the change hasn't been covered, the agreement will lose relevance, and will be more unlikely to be upheld by the court over time as a result. Well, how do you combat that? Well, you combat that by making provision within the nuptial agreement for review clauses, which of course is a disadvantage as well. It's pretty standard to have in review clauses, so as to cover, amongst other things, changes in a relationship over time. Reviews, however, lead to more negotiations, more legal fees, timing taken in refining agreements. And where there's a change of circumstance, those negotiations can take place at inopportune or unfortunate times and lead to somewhat awkward conversations as a result. And also, what happens if you don't agree those changes? I said earlier that prenups can be romantic. Well, by implication, they can also be unromantic, let's be honest. Thinking about what will happen if you get divorced isn't the most romantic thing to think about when you're due to get married and you're in the lead up to the marriage date. And it can be costly, whilst cheaper than going to court and litigating, it can still cost a few thousands of pounds to properly negotiate and draft a nuptial agreement. And that's a few £1,000s each. And that's before you look at the reviews after 5, 10, 15 years, or if children are born. And finally, there are a myriad of emotional considerations to think about, whether it be family influences, parental upset, or vulnerability of an economically weaker party. There are lots of emotions when negotiating a nuptial agreement, and it can feel like you're walking a bit of a tightrope with your respective families in the run up to the big day. Really, that's a whistle-stop tour of nuptial agreements. This is a far wider subject than maybe that 10, 15 minutes was, and I could probably go on for a lot longer, but we're limited to 3/4 of an hour today. If you have any questions, please do email me or put that question in the chat, and I'll try and answer it at the end, as I say. And I can see we have got some questions coming in, so that's great. The next thing we can go on to talk to you about is divorce itself and a change in the law. So we've been talking about nuptial agreements when parties are due to marry or are married. But what happens when marriages end? Well, many of you may have seen the change in the law that happened on the 6th of April this year. If not, on the 6th of April, the Divorce, Dissolution and Separation Act came into force. This changed the law so that parties no longer had to prove that one of 5 facts exists to enable parties to get divorced. They just had to prove now that they've been married for at least a year and to confirm their belief the marriage had broken down. Now, this was a good thing for us. As for many years, most divorce petitions were issued either using the fact of one of the parties' unreasonable behaviour or their adultery. Both of these associated fault to a marriage ending and resulted in problems between separated couples being exacerbated at the outset, making negotiations regarding children or financial matters all the more complicated and costly. Those petitions were always ever one side of the story and could lead to petitions being defended or cross petitions being issued. This again just increased cost, upset and delay. If these facts didn't exist or parties didn't want to rely upon them, couples had to wait either 2 years from separation if they agreed to divorce, or 5 years if they didn't divorce from separation. And that was one of the main reasons really why the change in the law came about. If you have 5 minutes after this webinar, do take a look at the Supreme Court case of Owens and Owens from 2018, as that is the case that ultimately changed the law in this area. Thankfully, though, that's all resigned to history now. As I say, following the 6th of April, so long as you can prove you're married and have been married for a year and have jurisdiction to get divorced in the UK, that's all you need. Anyway, I think that's enough from me for a bit. Aimee, it's over to you now, I think.
Thanks, Chris. Chris has spent some time taking you through the steps that increasingly people like to take to give themselves some protection when marriage is on the horizon. But what happens when couples aren't married, but they're living together? The starting point in that situation is entitlement is very, very different. People who live together will not have the same arguments when the relationship breaks down, or the same claims that they can bring before the court. And importantly, there is no legally recognized concept of common law wife. I have had people say to me, after very long relationships, perhaps people in their 50s, 60s, well, of course, he or she will get half of the pension because, you know, that she's the common law wife. And I think people are still quite surprised that that legal concept doesn't exist. There's often discussion, and certainly there's been more discussion in the past few years in the legal world about whether there's enough protection for cohabitees and whether we're really getting the balance right, or whether there should be more. We're not going to change the law today. That's a matter for Parliament. Today, I'm going to talk about where people stand when they're living together and it doesn't work out. So we know already that the claims a cohabitee can bring are really much more restricted. The law is governed by the Trusts of Land and Trustees Act 1996. We call it TOLADA for short. And what it allows people to do is to bring a claim against the other in court in respect of the property they've had. And those claims can be for how the property is used, ownership of the property, interest in the property, and occupation of the property. Depending on the complexity of the case and depending on the value of the claim, you might be heading off to the county court or the High Court, and the High Court deals with the more complex, valuable matters. Part of what I'm going to talk about today is trusts, but those may not be the kinds of trusts that you in the business world are familiar with. I'm not talking about Isle of Man, Jersey, other exciting places where you can do lots of fancy things with trusts. I'm talking about a different kind of trust. And where we really start is what was happening when people bought the property that they are now arguing over. If they bought the property in both their names, perhaps they bought it in one person's name. So what we usually do is we go back to land registry documents, and we'll see on land registry documents whether or not there's one legal owner, two legal owners, or more. And that will tell us the legal position as to who legally owns the property. But given the lawyers are involved, we'll say that's not always the whole story. It's rarely the whole story when disputes arise. So what we have is a general principle that we all follow, set down assumption that the court follows, which is equity follows the law. And you might hear that said. Equity follows the law. What does that mean? An example of equity following the law is the starting point of presumption is if there's one legal owner, the legal owner owns it all, end of. But it's possible that you could be the sole legal owner on the title deeds, but have no actual interest or share in the property whatsoever. And I'll give you an example. Someone could be a trustee. A child could have inherited a property. Nobody under the age of 18 can own property. So person stands as a trustee. A legal owner is registered at land registry, but the child is the 100% beneficial owner. Actually, all of the interest in the property belongs to the child. When they're 18, they might become a legal owner, and the trustee steps aside And the child is therefore the legal owner at land registry, but also the beneficial owner. The child was always the true owner in lay terms. So let's take it a step further and look at couples. When two people buy a property together, one person might be the legal owner, but the beneficial ownership, and you'll hear that term a lot, is divided between them. The beneficial ownership could be fixed or it could be fluctuating. The document that's quite important or really essential to look at is the Tr1 document when the parties are buying the property, because it will tell you quite a lot of information to get you started, as well as the conveyancing file if a conveyancing solicitor still holds that in the archive. So the legal title of a property is conveyed into parties' joint names now by a Tr1. The Tr1 form at land registry can contain what we call an express declaration of trust, or you can draw up a separate document, which is also an express declaration of trust. That will set out how you own the property and what your share is and how it's all worked out. And increasingly, people are taking that step. They are wanting to give themselves as much certainty as they can by setting it out in black and white. But much like Chris has said, those kinds of conversations can be difficult if you're about to move in together, and they're not always seen as the most romantic. It's also not foolproof. An express declaration of trust can be very difficult to overturn or to persuade the court that somehow it shouldn't follow what's set out there in black and white, but it can be undone. And I'll give you some examples of how people have successfully unpicked and persuaded the court to move away from what the express declaration of trust says now. So you might have fraud, if you can prove that. You might be able to prove undue influence or mistake. Perhaps this document is fundamentally different to what the person intended to sign, or you might have arguments about capacity or incapacity in terms of the person's mental state at the time and understanding. But what if it isn't set out in black and white? What if there's no express declaration of trust? That's where it gets more complicated in order for the court to try to work out and untangle what everyone should have now the relationship has broken down. What comes into play? Well, the court will look at the parties' common intention, and the court can infer a common intention. So the court can decide for itself what it believes the couple's intention really was. So it'll look at the facts. Sometimes the court might look at a document that perhaps parties have agreed during the relationship about how things would work. But if not, the court will have to look at objectively at the parties' conduct. So what was going on during the relationship and what's relevant to what the court has to decide. So what was one party's intention and what was the other person's understanding of that? That can be words, it can be conduct, how people behave, it can be discussions that people have had during their relationship, can look at how they ran their finances, can look at how the property itself was financed. And you can quite imagine a fairly obvious set of hypothetical facts. Someone says, my name's at the land registry is owning this house. I'm on the mortgage too, but you give me half the mortgage repayments every month. And this is really our house, isn't it? Despite what it says at land registry, it's really our home. In the simplest case, the parties might have very expressly, the court might find that in discussions that parties have expressly agreed orally, something contrary to what land registry says. The difficulty is that people don't tend to run their relationships like they run their businesses. Most people are just trying to get on with their day-to-day lives and have the happiest relationship that they can have, and they are not getting one another to record things, to document things. More complicated situations might be where there never was a discussion. People might not say on the 15th of June 2022, we did a deal on this. Relationships don't work like business deals. So the court will look at what they both understood the position to be, and the court can infer that there was agreement just from the circumstances and how they behaved. That will come down to the parties' evidence. So what we call a constructive trust is where it's alleged that the parties had a common intention, that somehow they would both have beneficial ownership and they would both have a share. So it's something for people to be mindful of whenever they are in a relationship, what's being said and what everyone's understanding is, because it becomes more difficult then if the relationship doesn't work out. We then have a concept of proprietary estoppel. So this is another common example. One person might make the other a promise. Look, you put the extension on, or you put the conservatory on, it costs that person money, and then the person says you've got no interest in this property whatsoever. So the person is out of pocket, probably put money into the property, and the other person is then saying you don't have any interest in it. So the concept is really about someone acting to their detriment and the other person being guilty of unconscionable conduct and denying the other person's rights. And it does particularly arise in the context of home improvements. That's probably the most obvious example. And that person has acted to their detriment, but by paying for something. Those are the kinds of arguments that come up in cohabitee disputes in court. Well, what can the court do? The court can decide what it believes it was agreed, can infer an agreement, and it can then determine the shares that everyone has. And what the court can do is look at financial contributions, but people need to be aware that that's not where it ends. The court doesn't simply do or carry out a basic accounting exercise and decide on that. The court could look at a range of factors. They could look at the fact that someone might not have made any financial contributions, but they might have given up work to look after the family, the children, and the purpose that this property was bought was to provide a family home. What that means is, in terms of deciding shares and what interest people have in the property and what they will get out of it, can be an unpredictable exercise, and it carries with it a degree of uncertainty. What could the court do at the end of the day? Determine those shares, determine if there should be a sale of the property and order a sale of the property, maybe order a sale at a later date if there's young children living at home. So that's a little bit about when marriage isn't on the horizon, but people are living together. There is a route of redress if you are not able to sort it out, and we call it tolada. And those are the common arguments that you might find and the options for the court to try to sort it out and resolve it. I'm going to hand back over to Chris.
Thanks, Aimee. I've just been having a look at a couple of the questions, actually, and I think there's at least one for each of us. So stand by your beds. Right. So back to me. Business assets and the court's approach. So in cases where there are businesses or business assets, those assets are usually the biggest and probably the most complicated assets the court is asked to consider. And so finding out what those business assets are worth is crucial to settling the case. As such, the start point for the court is that the assets are disclosed at the outset of the case in the standard disclosure document, and that's called a Form E. The Form E is used to disclose all the assets, all the incomes, the debts, the pensions, the needs an individual has, and these forms are exchanged right at the outset and in advance of the first court hearing. So really where you start is the business asset should be disclosed in that document, and the business accounts also provided. But how do you attach a value to the business, which is what the document asks for? And that can be really difficult. All businesses are different. Businesses in different sectors are valued differently. And there's no one comprehensive way of valuing a business. And so really the start point is to give your best estimate. Start at the business accounts, the net assets, the value of any order book, business plans you may have, and the actual or prospective liabilities that are owed. Whilst it's unlikely to be accepted by the other side, your accountants can also provide a guide estimating the value of the business and explaining why they have come up with that number. And this can similarly be disclosed in the Form E. And it might be, depending on the type of business, the valuation that's provided, or the size. That's as far as it goes. In the event not, however, the court at the first hearing is likely to order an independent expert is appointed to value the company, and that report report its findings back to the court. That expert would be 99 times out of 100 instructed as a single joint expert. This means that one expert is instructed jointly by both the parties. This prevents the parties from getting their own experts, who will undoubtedly come to their own and differing conclusions, which would result in more costs and time-consuming proceedings, as experts are cross-examined by a judge, and it's that judge who determines ultimately which, if either of those experts is correct. By getting an SJE, you avoid that. But still, the SJE can be costly. Valuing a business can range from £6,000 or £7,000 to upwards of £20,000. Their reports can take a number of months to complete, especially if there are significant assets of the business, such as premises, which may need to be individually valued first by another expert, or similarly, if there are complicated business structures that exist. So it can take a fair bit of time and cost a lot of money. In essence, though, if an SJE is instructed, they'll probably look at the following things. So perhaps obviously the overall value of the business, which in recent years has usually included a provision for the impact of COVID, the prospects in the short term for the company as we come out of COVID restrictions would also usually be reported upon. Valuing a business is really a question of the expert evaluating all the evidence I've alluded to above. But the expert will still have a degree of estimating, gauging, interpreting, and a final number from that evidence. It's still that individual's gut instinct to an extent. But sometimes an expert calculates something called EBITDA. You might have heard of the abbreviation EBITDA, or earnings before interest, taxes, depreciation, and amortization. And that EBITDA figure is used as a way of valuing a business. You get to that number and then apply multiples of that number to come to the value. The report would also probably look at, if you own a company with others, the valuation of your individual shareholding. And that's important, as in that instance, it usually considers any discount that should be applied if you've got a minority shareholding, or the marketability of selling your shares if you are a minority shareholder. The report will look at the liquidity of the business, i.e. how much money is in the business that can be extracted, and the impact of that extraction on the business. This is particularly important if spousal maintenance may also be claimed, as obviously extracting capital from a business will affect cash flow and any incomes and dividends that can thereafter be taken by an owner, which would pay ongoing spousal support. The report would look at the most tax efficient way the funds could be extracted from the firm, and by implication, look at tax implications generally as part of the valuation. And finally, when you're acting for the business owner, who is the entrepreneur, the effect of the value of the business, if the owner of the business no longer work there. If you think the value of Virgin without Richard Branson, for instance, or Dyson without Sir James Dyson. After that report has been filed and that number provided, both parties have the opportunity of asking questions of the expert for clarification purposes, and indeed if issues still arise after those questions are answered, experts can be called to give evidence at a final hearing. But that's really the exception rather than the rule. The SJE report and probably the questions are probably as far as most cases go when we're looking at valuing a business. Well, if that's how you do it, what are the strategies that exist to protect your assets on divorce? And I think I'm now over to Aimee again.
I've just been looking at some of our questions, some interesting ones coming through. Bear with me. So I'm looking at, for our final few minutes, just strategies to protect businesses on divorce. This can understandably cause a great deal of distress, people worried about what will happen to their business on divorce, what will happen to their income, and potentially people also have businesses which they hope to be able to pass to children and or potentially grandchildren. So there can be a big concern about a ripple effect. Business assets can form part of what we call the matrimonial pot, and what we put in the matrimonial pot is capable of being divided between the spouses. So there are arguments which arise which try to keep businesses out of the matrimonial pot, and people might raise a variety of arguments. They might say it was inherited, that it came before the marriage, a variety of issues that might be raised just to try to mitigate how that business is treated by the court and how the assets could be divided. Non-matrimonial and matrimonial property, what goes into the matrimonial pot for division and what doesn't is a whole topic in itself. It's quite a big area of debate on divorce. So that's probably beyond the scope of what we're talking about today. But one thing I will say is there are limitations on arguments about non-matrimonial property, and the court can very often be guided by the needs of the parties rather than the status of the asset and whether or not it's matrimonial or non-matrimonial. And there is a whole body of case law and guidance telling courts and lawyers how to deal with those issues. But certainly in some cases, a business is seen as a resource that's available and could be put to use by a court to achieve a fair outcome. One way to protect a business on divorce, or to try to protect a business on divorce, might be what we started talking about today, which was prenuptial agreements, and trying to craft some wording and some consensus about how the business would be treated if it were to break down. That's one that you will be aware of already. There are other arguments. If the business provides an income stream for one of the spouses, then if the business goes, then there is going to be some concern on the court's part that that person will lose their livelihood and their living. Also, if one spouse is asking for periodical payments or maintenance every month to be paid to provide them with an income, then how is the other spouse able to do that if they lose their business or if their business is badly affected by the divorce? So it can be used as a strategy to ensure that it stays where it is, it stays running, and that obligations are met in other ways. So paying monthly maintenance, for example, is one. There can be strategic arguments about business assets. There might be arguments about paying a lump sum to the other party. Does a judge think it could be raised by using the business? Will taking money from a business leave the business in trouble? Of course, there's an infinite number of types of businesses and way things are run. So there's not one hard or fast rule. We also have arguments about the attractiveness of retaining businesses compared to cash in the bank or property. Of course, the value of a business is going to be different to liquid assets. It might be argued that the spouse who's keeping the business is in fact keeping the riskier asset. You don't know what might happen in business going forward. You don't have a crystal ball. And if there's a downturn in the business, then you are suffering that hardship. And I think COVID is probably a very good example of unforeseen circumstances that people won't have thought of, but have ultimately had effect on some industries. We often talk about who's keeping the copper-bottomed assets and who's keeping the illiquid risk-laden assets, and it's not like for like. We might have arguments about a party who wishes to receive assets having a lump sum rather than having shares, if there is a fear that share price might go down. If there are third-party shareholders, of course, that can raise difficulties for spouses on divorce who may object to transfers or difficulties with articles of association. So the court might look at different avenues, and there are certainly arguments where things become far too tricky, and there are other assets within the marriage that actually have more utility and can be grappled with to try to reach a fair outcome without getting into complications of shares and whatnot. There was a case a few years ago that in respect of transferring business assets owned by the business, that would only be happening in very limited circumstances. There are other issues to think about on divorce, wider than just who gets what. There can be other subtleties as well that it's worth taking advice on. Are the parties to remain both shareholders after the divorce? Does there need to be a shareholders agreement? If money is coming out of the business, what's the most tax efficient way to do it? It's worth people sometimes getting some specific, discrete tax advice on efficiency. There is a limitation to what the court can do itself. Judges are not accountants, they are not forensic accountants, so that's why we are often asking to supply them with the evidence that they need to come to the right decision. We can't expect judges to be jack of all trades, and the same goes for valuing the importance of valuing businesses, for also making the court aware of tax implications so that the court can take that into account if it needs to. You might be wanting to consider agreements on people resigning as director, non-compete agreements, and other issues that arise that won't necessarily arise if you're just transferring real property. So it's important to be mindful of. We've talked about ripple effect before, but there's a ripple effect in terms of trying to deal with businesses on divorce and making sure that all bases are covered, not just from a matrimonial lawyer's point of view, but from a commercial point of view as well. So those are the arguments that often come up in respective businesses on divorce. I think that now we are going to, in the few minutes that we have left, or I can see we've already run over by 5 minutes, see if there's any questions. And I think that we won't probably get through them all, but Chris had spotted questions already. I think you're on mute, Chris.
Yeah, I remember that after 2.5 years. Right, I think I've got the short straw because it seems that most of them are prenup based, but I'll run through them as quick as I possibly can in the time that we've got. The first one says, quick question, strikes me that over 55s prenups are less complicated. I think the question really gets to, are prenups for the over 55s still as relevant? And the answer to that is really yes. The majority of prenups are probably people in their 50s and 60s. The reason for that, as I say, is if you remember what I said about the reasons why people enter into prenups, it's previous relationships bringing significant assets into a relationship. Well, those significant assets are more likely to have been built up over a working career rather than when you're in the 20s, unless you're a footballer or a pop star, I suppose. If you've got children from a previous relationship or have been married before. So yes, over 50s, over 55s, still prenups are really, really relevant. Second question, I think, is if you are a child-free woman, don't have children, don't plan to have children, does that make the agreement probably more binding? And what's the best way for a woman to protect herself? Is it better just not to get married? Well, I think the answer to that question is, first thing I'd say is you never know. I've had a number of clients who've said, we're not going to have children, and then have had children. You don't know if you're going to have children by accident, whether or not you are going to adopt godparents if there's a death in the extended family. And, you know, I think the point is you never say never. But if it's unlikely there are going to be children, then obviously, yes, that makes the prenup or the postnup probably a bit more persuasive to a court, because one of the things I talked about is you can't crystal ball gaze. Well, if those things are unlikely to happen, then it's less likely that the terms of the prenup will be departed from over time. And if the prenup still is more relevant in 5, 10, 15 years, and all the other parameters are continuing to be met, then yes, it is more persuasive to a court. Hopefully that's answered part one. Part two, what's the best option for a child-free woman to protect herself? Is it better not to get married? Well, you know, you don't decide to marry or not marry because of the financial consequences. If you choose to get married, I think you know that you can protect yourself. We've talked about pre and post nups today. Aimee's talked about trusts of land. If you're not going to get married, so protecting property, there can be bespoke trusts that could be set up prior to or during a marriage to protect assets. And of course, there's also the provision of wills. You can make a will and you can decide who you want to leave your assets to in a will. So there are a number of avenues you can pursue to protect yourself. And I think probably the black and white answer of just don't get married is probably not the right answer in most cases, shall we say. That's question two. Aimee, do you want to go on to your question now that's in the Q&A, and then I'll finalize the last couple of questions, if that's okay?
Yeah, absolutely. I've seen a question about Tr1 and changing it by implied constructive trust. An express declaration of trust is extremely difficult to unpick. If we've talked about fraud, undue influence, mistake, capacity, if parties are in a relationship and want to feel things have changed or something has happened that has caused them to think differently about how they hold the property, then really they should be drawing up or revising their declaration, because those declarations are so persuasive for court purposes. So I wouldn't be leaving it to just having discussions or doing otherwise. You would be thinking about going the whole hog and having another declaration.
Thanks, Aimee. If I can do the next two, the question from Mark and the question from Angela and David. Aimee, could I ask you to just finish off the last couple of questions while I'm answering these ones, if that's okay?
I'll have a look and see what else I can deal with. Yep.
Excellent. Well, answering Mark's question first, I think Mark's talking about the situation that occurs when one person wants to leave a business or change the nature of the business and the other person doesn't want to do the same thing. I'm afraid that's outside of the scope for today's webinar. That's more of a company law or commercial law question. I think both Aimee and I would be possibly not the right people to answer that question. I'm sure 3PB have commercial barristers who can answer that advice, and certainly we have commercial lawyers at Anthony Collins who can do similar. If you do want that specific advice, please do get in contact with us. The next question is, if there's liquidity in a business, but that's already accounted for, e.g. staff, cost growth, can these future plans be protected? Well, I think that question probably goes to business valuations. Yes, is probably the answer with a switched on SJE. It may look as though there is liquidity in the business, but I'm sure you will have provided the business plan to the SJE. You will have shown the SJE what that money is earmarked for, and usually with business valuations, business owners have the opportunity of explaining their business to the single joint expert, and so that can be accounted for in those conversations. Hopefully that answers that question. Can a prenuptial agreement state, this is David's question, that shareholdings and businesses are owned completely by spouses? Can you both keep your businesses 100%? I think that goes to the information I gave earlier. Yes, so long as it's fair, and so long as it meets needs. So long as what there is still meets everybody, in particular children's needs, and so long as the overall outcome represents a degree of fairness, yes, you can make specific provision to retain business interests, and quite often that's the reason for the prenup. I think that's the last question for me. I think that they're still coming in. Aimee, over to you in the time that we've got left.
I'm very conscious of the time. I've been asked a question about shareholders and third parties, and if a spouse agrees to be treated as a bad leaver in the event of a divorce, would that be upheld by the family court? I think there's a real broad range of factors that would go into what the court is looking at. So I think that's probably too fact specific to give any general advice on. It's going to be helpful to you, but it's one where probably some real specific legal advice should be sought. I think that was all, Chris. If you haven't spotted anything else, I think we're handing back over to Chloe now.
I think we're out of time in any event.
Thank you, Chris and Aimee, for joining us today and sharing your expertise and knowledge with us. And thank you all for joining us this morning as well. The session has been recorded and will be sent out to all attendees later on this afternoon. And with that, that is the end of the webinar. So a big thank you to Chris and Aimee.
Thank you. Thank you.